Hello kids, let's start with High Court and Subordinate Court, the last chapter of our history and civics. So, as per our judiciary, we are provided with one court which is at apex. Yes, and that was our Supreme Court, which already we have discussed. Below Supreme Court, we have High Court. Every state is provided with High Court. But however, as compared to the number of states, we have less number of high court. We have only 25 high courts. Why like that? Because there are some states whose jurisdiction extend over more than one high court. That is the reason that we don't have same number of states and same number of high court. For example, Maharashtra High Court will have its jurisdiction over Goa, Dadra and Nagar Haveli, Daman and Diu, etc. So this is one of the example where I have explained that some states high court can have jurisdiction over more than one state. Out of all the union territories, Delhi is the only union territory to have high court of its own. So let us understand about all the details of high court. To start with, yes, composition. Every high court will have one chief justice. Every high court will have other judges. Now other judges in every high court will not be same. It will vary. The number of other judges in every high court will be different. Some states might have more number of other judges, some states will have less number of other judges. Now, besides that, every state will also have one additional judge who could be appointed for not more than 2 years to clear the arrear of work, to clear the burden or pending work. But remember one thing, he cannot be appointed for more than 2 years. Then there can be also acting judge. There can be also acting judge. If in case permanent judge, okay, other than chief justice, if permanent judge is absent, in that case, or if permanent judge due to any reason is unable to perform his duty, there will be acting judge. So this is the composition. This is the composition of High Court. Now, to be a judge of High Court, what qualification you should possess? So to be a judge of High Court, A, you should be of course citizen of India. As I have always said, this is a point which is a default, you have to write this point. Your age should be less than 6 to 62 years. Your age should be less than 62 years. Third, you should have worked for 10 years as an advocate of High Court. If you have worked for 10 years as an advocate of High Court, or the other qualification is, if you work for 10 years in any judicial department of our country, in any territory of our country. So to be a judge of High Court, again I am repeating what are the qualifications needed besides being citizen of India. A, your age should be less than 62. You should have worked for 10 years as an advocate of High Court, or you should have worked for 10 years in any judicial department in any territory of your country. So kids, when you learn qualification, please remember the key word besides being citizen of India, your age should be less than 62 years. You should have worked for 10 years as an advocate. Where? In High Court. Or the other qualification is, you should have worked for 10 years in any judicial department of our country, in any territory of our country. This gets you qualified to be a judge of High Court. So we understood who all are there in High Court. What qualification is needed to be eligible to become a judge of High Court? Now let us understand further that who appoints these judges. Let us understand who appoints them. So सबसे पहले Chief Justice will be appointed. So Chief Justice is appointed by President. But in that case, President is going to consult two people. Governor of the concerned state. He will be consulting Governor of the concerned state. He will also be consulting CJI, Chief Justice of India. Yes, he has to consult Chief Justice of India because as I told you in Supreme Court that Chief Justice of India is the head of Indian judiciary. So President will take opinion of CJI, he will take opinion of that governor of that state and then he will appoint CJ for that particular state. Then we have other judges. Again they will be also appointed by President. Now in this case, President is going to consult, of course, governor of that state, CJI, but plus he will also be consulting. So he will consult governor, he will consult CJI, but now in this case, when he is appointing other judges, he will also consult CJ, that is Chief Justice of that state. Both the judges are also appointed by President. So this is who appoints the judges of High Court. High Court judge can continue to work till he attains the age of 62. High Court judge's independence is also maintained. How? Same way, they are free to announce a decision. Same way, they can be punishing anyone for contempt of the court. Their salaries, their free benefits that they enjoy, they cannot be reduced. Their salaries are charged on consolidated fund of the state. What about the retirement? Can they practice after retirement? They can practice but only at two places. High Court judges can practice after retirement in Supreme Court, or they can practice in those High Court where they have not served before, or they can practice in those High Court where they have not served before. If they don't practice, of course they are given handsome pension. Any High Court judge can be removed on the grounds of proved misbehavior or incapacity by the process of impeachment. And yes, the process of impeachment for the judges of Supreme Court and High Court is same. High Court judges can also give their resignation letter in case they don't want to continue on that post. Their resignation letter will be addressed to President. Also one more thing, sometimes a judge of one High Court can be transferred to other High Court. A judge from one High Court can be transferred to the other High Court. Means from the one state ka High Court, they can transfer the judge to High Court of other state. Who can do this transfer? Yes, President. This transfer can be done by President. But before this transfer is done, President has to fulfill 4 conditions. So President in our country has power to transfer judge from High Court of one state to High Court of another state. But before that, he has to consult CJI. He has to consult 4 senior most judge. He has to consult 4 senior most judge. he also has to consult Chief Justice of both the High Courts. What do you mean by both the High Courts? The High Court from where he is transferring and the High Court to where he is transferring. He will consult CJ of High Court from where he is transferring, and he will consult CJ of the High Court to where he is transferring. And of course, he has to give, a judge who is getting transferred should be given enough extra compensation allowance. So these are the 4 conditions which should be fulfilled before transferring judge from High Court of one state to High Court of another state. Let us go further with the powers and functions of High Court. So let us talk about powers and functions of High Court. High Court has original jurisdiction. High Court has original jurisdiction. Okay, they have original jurisdiction on what? They have original jurisdiction on 5 cases. That means there are some cases which can be taken to High Court and it can be heard and decided by High Court in first instance. And those cases are called as High Court having original jurisdiction. So first, if there is any matter of state revenue, any matter of state revenue and its collection can be taken directly to High Court. If there is any case with respect to marriage, will, divorce, company law, or if there is any case with respect to contempt of the court, all these cases will have High Court will have power of original jurisdiction. If your fundamental rights are violated, in that case also the case can be taken directly to High Court. And yes, you all know very well what is High Court going to do in this case. They will issue the written orders, and those written orders are called as writs. W-R-I-T-S. High Court will also have original jurisdiction over the cases which need interpretation of Constitution. The cases which needs interpretation of Constitution, this power is called as judicial review. In those cases also, High Court can have original jurisdiction. And last, the cases such as election petitions. Okay, such as election petitions. Okay, cases like election petitions challenging the elections of member of parliament or elections of member of legislative assembly or member of local bodies. So whenever you want to challenge election of MPs, you want to challenge election of MLAs, or you want to challenge the election of the leader of the local bodies. Any such cases of election petition challenging election of MPs or election of MLAs or election of the member of local bodies, those cases can be directly taken to, yes, High Court. So these are the 5 cases where High Court will have its original jurisdiction. Going further, so this was the first power of High Court, in which we spoke about those cases where High Court will have its original jurisdiction. Now second function, advisory jurisdiction. So now there are some cases where there are some situations when High Court can give advice. Whom does High Court give advice to? High Court can give advice to governor, or High Court can give advice to any government department, or High Court can give advice to state legislature. If governor or any government department or state legislature, if they need advice on any constitutional matter or on any matter of law, High Court can give advice to them, but only if they seek that advice. This advice is not binding on them. If they don't like the advice, it is not binding on them. So this is second power of High Court, called as advisory jurisdiction. Let us go further with the third power of High Court, revisory jurisdiction. The third power is revisory jurisdiction. Again, I will repeat when I had mentioned in the Supreme Court also. The meaning of revisory is review, and jurisdiction means judgment. So revisory jurisdiction means to review the judgment. High Court can review the judgment. High Court will review whose judgment? High Court will review the judgment of subordinate courts. Sometimes High Court feel that subordinate court power, has used their power of jurisdiction in excess. Or sometimes they feel that maybe subordinate court did not follow a proper procedure in a particular case. Or they feel that in a particular case, natural justice has been violated. Or they feel some error had taken place in the procedure. Or they can feel that arbitrary authority led to wrong judgment. Arbitrary authority means some people try to misuse their power. There can be some politicians or anyone who tried to misuse their power, because of which it led to wrong judgment. In all this situation, High Court will review the judgment and will rectify whatever error has taken place in that judgment. This power of High Court is called as revisory jurisdiction. Next we have is judicial review. The next function is judicial review. Again, in this, High Court is going to review. What is High Court going to review? High Court will review law. High Court will review law. High Court can review any order. High Court can review any ordinance. But this law, this order or ordinance should be the one which should be passed by state legislature. Which should be passed by state legislature. So if state legislature, that means a state government, has made some law, has passed some law, or has passed some order, and High Court feel that law is contravening, means going against our constitution. If they feel that law is not as per the provision of the constitution, or they feel that this law is violating our fundamental right. So anytime they feel that any law which is violating our fundamental right, or any law which is contravening our constitution, in that case High Court will declare that law as null. High Court will declare that law as void, and that law they will remove it permanently from our constitution. They will declare that law as null. They will declare that law as void. They will declare that law as null, void, and will remove it. This power is called as judicial review. I'll repeat again. High Court has power to review law, order or ordinance. passed by state legislature. And if they find out that law is contravening the constitution or is it violating the fundamental right, they will declare that law as null void. This power of High Court is called as judicial review. High Court is also a court of record. The next power talks about how is High Court a court of record. So we all know very well that Supreme Court के judgment को record किया जाता है. Same way High Court judgments and orders are recorded, are preserved, so that they can be used, they can be referred in future. Okay, they can be used as evidence, they can be used as testimony, they can be used as future reference, they can be used for future reference. In fact, High Court judgments are also in the nature of, yes, in the nature of precedent. What do you mean by precedent? Whatever cases has come in High Court and whatever judgment has been passed by High Court, if similar cases appear in the subordinate court of that state, they are bound to take similar decision. So High Court judgments are used as a reference. Okay, are used as reference, are binding, means subordinate court पे वो binding है. Judgment taken by High Court in a particular case is binding on the subordinate court of that state, but not on the subordinate court of other state. So in short, subordinate court of that state is bound to take the similar decision if similar cases comes in that court, but it is not binding on the subordinate court of other state. This is called as court of record. And also High Court judgments are recorded, please underline that point, so that a person can be punished for contempt of the court. A person can be punished for contempt of the court. So that was court of record. So why are High Court's judgment recorded? Evidence, testimony, used as a reference in future cases, and they are in the nature of precedent. It means whatever judgment has been taken by High Court in a particular case, in similar cases, the subordinate court of their state are bound to take similar decision. And we also record the case so that we can punish a person for contempt of the court. And now, last is appellate jurisdiction. Appellate jurisdiction, it means that if any civil cases or any criminal cases which has been decided by subordinate court, and if you are not happy with the judgment, if you are not happy with the judgment given by subordinate court, by the way of appeal, you can take that matter to High Court. High Court will hear your appeal in both civil and criminal cases and will do the needful. Before I do appellate jurisdiction, let me just give you a little briefing about subordinate court. So subordinate court we have at two levels for two type of cases. We have subordinate court for civil cases. We have subordinate court for criminal cases. For civil cases, the subordinate court is called as Court of District Judge. For criminal cases, it is called as Session Court. It is called as Session Court. The head of the district court is called as District Judge. The head of Session Court is called as Session Judge. In short, criminal cases at subordinate level, they are called as session court and they are presided by session judge. Civil cases at subordinate level are called as court of district judge and they are presided by district judge. Okay. Now, first let's understand appellate. Along with this, so appellate jurisdiction can be used for both the type of cases, civil cases and criminal cases. Civil cases and criminal cases. So civil cases में you can appeal against a judgment of district judge in case it is a matter of land revenue, or second situation when you can appeal is there can be cases where blatant injustice has been committed by a tribunal. It means a very obvious, very clear and very harsh injustice has been done by a judge. In that case, you can appeal. And if High Court find it to be a blatant injustice, High Court will quash the order of the tribunal. In this both the civil cases, you can appeal from subordinate court to High Court. What about criminal cases? So coming back to this, criminal cases are presided by session judge. But besides session judge, of course there is a session judge for criminal cases. There is additional session judge. There is assistant session judge. There is chief metropolitan magistrate. All these judges at different level are handling session court. So in case first, if session judge or additional session judge, okay, if session judge or additional session judge, if out of both of them, any of them has given judgment where you have been imprisoned for 7 years, where the person has been imprisoned for 7 years and that judgment has been passed either by session judge or by additional session judge, okay, or by additional session judge. In that case, you can appeal against their judgment in High Court. Second situation, in case assistant session judge or chief metropolitan magistrate, okay, if chief metropolitan magistrate or any other judicial magistrate at that level, if out of them anyone has given imprisonment or judgment where you have been sent to 4 years imprisonment, in that case you can appeal against their judgment. Third, order of acquittal. If order of acquittal has been passed, by a session judge, order of acquittal means to declare anyone as non-guilty. So if anyone has been declared as a non-guilty by session judge, you can appeal in, you can always appeal in High Court. And last, death sentence. Death sentence has to be confirmed by High Court. So these are the 4 situations under criminal cases when you can appeal in High Court. Now kids, coming back to our subordinate court. The subordinate court at civil, as I said, is district judge. At criminal, it is session judge. But of course, there is additional session judge, assistant. Now, all these judges are appointed by governor. They all are appointed by governor. Governor will be appointing all of them in consultation with Chief Justice of the concerned High Court. And I want everyone to mark this point, very important. It's a point number 3 in distinguished table of District Judge and Session Judge. So all these judges are appointed by governor of that state in consultation with Chief Justice of the High Court of that state. Also, let me add one more thing. District Judge is also additionally holding 2 more positions. What are those 2 more positions? He is also holding the position of Deputy Commissioner and District Collector. Deputy Commissioner and District Collector. These are the 2 additional posts which are held by them. Deputy Commissioner and District Collector. So that is the distinguish of Court of District Judge and Session Judge. Now the last part of the chapter talks about Lok Adalat. Yes, it means People's Court. Though it's a very small topic, but especially for short and MCQ, it is a very important topic. Lok Adalat means People's Court. The concept of Lok Adalat was introduced on the recommendation of P.N. Bhagwati, Justice P.N. Bhagwati, by Legal Service Authorities Act of 1987. It was set up to settle disputes which were not very intense, which could be settled with little negotiation, little compromise, especially for those section of society who were not in a situation to hire lawyers. Also, this was set up so that people can get speedy justice. So what are the advantages of Lok Adalat? Lok Adalat advantages: first, it provides speedy justice. Second, it provides cheap justice because you don't have to engage the lawyer. So usually, you know what, kids, in this the retired judges का एक forum होता है, 3-4 judges का, there will be a panel. They will hear to both the parties. Okay, they will listen to both the parties, and then at their own level they will try to do investigation, and then they will try to come to some negotiation between both the parties where there is a win-win situation for both. Okay. So Lok Adalat provide quick justice, it provide cheap justice, it provide inexpensive, it also reduces the burden of other courts, and mainly it promote social justice because it is helping weaker section of society. It is also promoting the spirit of compromise among the people because they ask both the parties to bid compromise at their level. So that is the advantage of Lok Adalat. Please, important है, Lok Adalat का meaning and advantage is very important. So that was your High Court and Subordinate Court. Thank you.